I think we have some indications from the United States Supreme Court, thanks to a case of Brown versus the United States involving the Armed Career Criminal Act, and what this may mean for felons in possession of firearms under 18 U.S.C. 922 G1, the federal gun control statute for prohibited people, and an indication of what might be coming down the pike in the Rahimi case. Let's break it down when we come back. You're not going to want to miss this information. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of a brand new book, Israel Disarmed: What the October 7 Attacks on Israel teach Americans about the right to bear arms. We must always learn from the mistakes of others, so we here in the United States don't make those same mistakes. Very important information in that new book, Israel Disarmed. We'll talk more about that in a future video. All right, folks, so here's the story. It's my job on this channel, and yes, as you can tell, I just had a Fox News appearance, because if I'm in a suit, you can assume I'm on Newsmax or Fox News or something like that. So here I am in a suit today, just for you and beyond. Okay, so with that said, and hopefully my hair looks nice today. I hope I combed it and you're happy with it. All right, with that said, we have some really interesting information out of the United States Supreme Court in a case that was just decided called Brown versus the United States. There's actually a couple cases consolidated here. This case involves a federal statute, the Armed Career Criminal Act, which basically is an enhanced penalty for people that are particularly bad actors that have been convicted of multiple crimes over a period of time. I won't bore you with those details because that's not relevant to why this speaks, in my view, to where the U.S. Supreme Court, I think, is going with Second Amendment jurisprudence when it comes to violent felons versus non-violent felons. So just to step back for a minute and put this Brown case into context, and then you'll see how I think it plays out and why it signifies where the U.S. Supreme Court is going to go in interpreting their federal gun control statutes of 18 U.S.C. 922G, which, just as a reminder, that's the statute that lays out the list of prohibited people, felons, people subject to domestic violence orders, illegal aliens, people that are using drugs unlawfully, and so on and so on. So the U.S. Supreme Court, as you know, is hearing this case of United States versus Rahimi out of the United States Court of Appeals for the Fifth Circuit down there in Texas. The Rahimi case has already been argued. We're waiting for a decision by the U.S. Supreme Court in the next several weeks. The Rahimi case deals with the constitutionality under the Second Amendment's right to keep and bear arms of 18 U.S.C. 922 G8, which says that if you are subject to a domestic violence restraining order, you're not allowed to possess firearms during the pendency of that restraining order. The question of constitutionality is before the U.S. Supreme Court. Now, I've explained to you that I think what the Supreme Court is going to do is they're going to basically draw a distinction between violent people who have been found after adequate due process to be violent. And by violent, I don't mean metaphorical violence like he's a danger to democracy or something like that. But no, I'm talking about an actual finding by a court after a hearing with experts and lawyers and whatnot that says that a person is physically violent. They're either have or are likely to commit murder, rape, or kill themselves or do something that's physically violent, not metaphorically violent. I think that is where the Supreme Court's going to come out. And what I mean by coming out is this, that the Supreme Court, I think, is going to say that if there is an actual finding that you are physically violent, a violent risk to yourself or to others, and there's a finding that that's the case right now, then you can be disarmed consistent with the Second Amendment. But if you simply have been convicted or are somehow doing something non-violent, like a bookkeeping crime involving President Trump, where now that Donald Trump has been convicted in that absurd trial in New York, he's technically speaking a convicted felon and loses his right to keep and bear arms as a convicted felon for now, at least, until the appeal occurs. But again, there's no violence or physical violence associated with the case. And that is how I think the Supreme Court is going to be drawing these distinctions as to what types of people can be disarmed. And I think they're going to say the only people that can ultimately be disarmed are those people that are physically violent, and anyone that is convicted or subject to something that's non-violent, a bookkeeping mistake, a bookkeeping fraud, wire fraud, the Martha Stewart situation of lying to the FBI as part of an investigation. This sort of nonviolent stuff, I think, is not going to be a basis for taking away people's right to keep and bear arms under the Second Amendment. I think that's where the Supreme Court's going to go. So again, if it's a clear-cut case of violence, you'll be disarmed. If it's not violence, you won't be disarmed. Now, here is where I think the Supreme Court is going to struggle. And this is the middle ground. Specifically, we know that the current Supreme Court, as a general matter, does not like criminals. That's why if you look at how they handle death penalty cases, they basically generally as a general matter, rule in favor of the government, because the reality is, having worked on death penalty cases as a law clerk, for example, I can assure you it's extremely hard to get the death penalty in this country. If you have been sentenced to death and you've gone up and down the line for appeals multiple times, you've really done something pretty bad, and it's pretty apparent that it was you and it was bad and it was intended. It's not that easy to get the death penalty in this country, but I'm digressing. The point being that the U.S. Supreme Court right now generally is not super sympathetic that people have been convicted of violent crimes where there's no real debate that you did it. Okay, they don't like criminals. They think that's a violation and a disruption to ordered liberty. They're not a fan of that. So how is the Supreme Court going to deal? And this is why we're going to turn back to this Brown case and why this is so important and why I think this is a strong indication of where the court's going to go. Again, you have a spectrum here. If you're clearly violent, no guns. If you're not clearly non-violent like Martha Stewart, guns. That's how I think the Supreme Court's going to resolve. But there's these middle cases that are fuzzy, and that involves drug trafficking. Hear what I just said? Drug trafficking. Now, drug trafficking is the sort of behavior that if you're convicted of, this Supreme Court is not going to like you. They're not going to be, now they will make sure you have your rights for due process and the like, but once you have your due process rights and an appropriate trial and the Constitution has been honored and you're found guilty of this kind of drug trafficking, they're not going to be happy with you as a general matter, and they're not going to be particularly sympathetic for people that engage in drug trafficking. But here's the question presented, and this is why this Brown case is so important, and I'm making you the smartest person in the room, because I'm telling you something nobody else really has thought about except a few people at the Supreme Court level, and now I'm telling you. The drug trafficking question, whether or not that's going to fall on the side of being violent, like murder, rape, robbery, violent suicide, let's say, that sort of thing, okay? Physically violence, is drug trafficking where you're selling a lot of drugs into the marketplace, the black marketplace, of course. Does that fall as a violent crime where if you're convicted of this, you will be disarmed? Or does it fall on the other side of the spectrum where it's really more of a Martha Stewart nonviolent crime where you're doing drug trafficking? I'm setting aside drug possession. I think that's a different category. Drug trafficking, where you're actually the cause of selling a bunch of drugs into the community, you're selling fentanyl, cocaine, heroin, whatever it is, I think that will be viewed differently than just mere possession by the Supreme Court. They're not going to be happy with possession, but I think drug trafficking is a problem. And now I think we know what the Supreme Court is going to do, because in this case of Brown, they have said they view drug trafficking as a dangerous, violent activity. That's right. If you look at what the Supreme Court says in this Brown case, and the Brown case, I won't bore you with the details beyond to say that it involves whether or not a state conviction for drug trafficking, whether or not that counts as a predicate crime that can give rise to enhanced criminal sentences involving changes in the law and whatnot. Again, the sort of the legal question presented in Brown versus the United States just recently is not particularly important to our issue. What is important to our issue is the language I'm going to read from this case by the U.S. Supreme Court, which is telling us, in my view, that going forward, violent criminals will be disarmed as well as drug traffickers, because they view the activity of drug trafficking as an activity of physical violence. Let's turn to the Supreme Court and watch what they say, and you tell me if you agree with me. The government's interpretation also best fulfills ACCA's statutory objectives. Congress's general approach in ACCA was to single out offenses of a certain level of seriousness that involve violence. Hear what I just said? That involve violence or an inherent risk thereof. That's violence or an inherent risk thereof or of violence, and that are likely to be committed by career offenders. Because defendants here who have repeatedly committed ACCA predicate offenses are especially likely to inflict grave harm when in possession of a firearm, ACCA imposes a higher punishment when they do so. So you can see there that the Supreme Court starts off by pointing out that people engaged in violence or the inherent risk of violence, which drug trafficking is, because the only way to enforce your contracts, your agreements in the context of drug trafficking is you have to solve your problem outside of the court system, which means violence. So that, I think, is where the Supreme Court's going. But let's see what else they say in Brown, and you tell me if you agree. This is speaking to where they're going to go with the Second Amendment as to who can be disarmed and who cannot be disarmed. The Supreme Court continues. A prior drug conviction for an offense punishable by 10 years imprisonment augurs a risk of future dangerousness, even if the drug is no longer considered dangerous. That is because the conviction reveals that the defendant previously engaged in illegal conduct that created a dangerous risk of violence. Did you hear what I just said? A dangerous risk of violence, either with law enforcement or with others operating in the same illegal field. Okay? If left at large, such defendants present a serious risk to public safety. So there you have it. You see the court's talking about dangerousness or a heightened risk of violence. That's the key. And I think this is signaling that drug trafficking, which is what this Brown case deals with, these people had been convicted of drug trafficking offenses. Is this fall within the spectrum of dangerous, like rape and robbery and murder, or is it more of a Martha Stewart nonviolence? And I think this court case is saying that the Supreme Court's going to place drug trafficking on the side of the spectrum dealing with violence, which is probably very good for the Second Amendment community, because again, what we don't want is a law and order court to say that anytime you're convicted, you lose your right to keep and bear arms, because as we just saw in the Donald Trump case in New York, a lot of people get convicted of a lot of stuff that's nonsensical, having nothing to do with public safety, a la what we just saw with Donald Trump. But let me continue. I think the Supreme Court's decision in Brown gets even more detailed, and you're going to really want to hear this right here, right now, because it's going to speak to exactly what I'm saying and where the court's going. If left at large, such defendants present a serious risk to public safety. That risk does not cease to exist if the law under which the defendant was convicted is later amended or eliminated. For example, consider a person who distributed alcohol during Prohibition. Hear what I just said? Distributed alcohol during Prohibition. Not drink alcohol, distributed. Again, for example, consider a person who distributed alcohol during Prohibition. The later legalization of alcohol did not by any means ensure that those bootleggers would take up legitimate jobs. Instead, after the end of Prohibition, many of them simply shifted to other illegal enterprises. Quoting the Oxford History of the American People, stating that Prohibition led to the building up of a criminal class that turned to gambling and drugs after the 18th Amendment was repealed. The court continues. Likewise, the defendants here, that's Brown and Jackson's multiple convictions for serious drug crimes, are evidence that they may continue to commit a large number of fairly serious crimes as a means of livelihood in the future, and that risk remains true despite the technical changes to the federal drug schedules on which their arguments hang. Now again, you can see how the Supreme Court is equating drug trafficking to alcohol trafficking during Prohibition. And again, I'm talking about drug distribution, alcohol trafficking, not possession. And this, to me, if you read this language from the Supreme Court's majority opinion in Brown versus the United States, it's clear that where the Supreme Court is going is that, again, violent crimes, including drug trafficking, are going to give rise to you being disarmed under the Second Amendment. If it's nonviolent and you're not a drug trafficker, I think you're going to ultimately be fine. We will know a lot more about all this in the Rahimi case, dealing with the domestic violence restraining order situation, and also down the road with the Range case, which deals with 922G1, which is felons in possession law, and also the Daniels case, which deals with the possession of illegal substances while possessing of firearms. We will know a lot more about this in the next year or two, but it's pretty clear to me that the one debatable point that I've been thinking long and hard about is, how does this court that doesn't like drug traffickers, how are they going to deal with that problem, even if the drug trafficker does not engage in actual violence? And I did think they would find that as a dangerous activity because, again, the idea of extrajudicial help is there, and the only way drug traffickers can enforce their agreements is by violence, shooting people that don't do the deal right, or by threatening violence or something along those lines. But whatever it is, it's a physically violent activity to engage in drug trafficking. That's where I thought the court would be thinking. I didn't have any real proof of that. It was just a suspicion I had. But now we have proof that that is, I think, how the Supreme Court's going to come down in the question of whether or not drug traffickers are going to be dispossessed of firearms or disarmed because they're violent, or they're not going to be dispossessed or disarmed because they're not violent. And I think we're seeing where the court's going with this Brown case. So there you have it. Hope you learned something here today at the Four Boxes Diner. Make sure you check out the new book, Israel Disarmed, on Amazon. Don't forget to subscribe here. We're trying to get to 150,000 subscribers. Don't forget to follow me at X for more Second Amendment information at Four Boxes Diner. And we will see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.